Earlier, in September 2018, the Ministry of Corporate Affairs, or the MCA, notified the company's Prospectus and Allotment of Securities Third Amendment Rules 2018. As per the amended norms, a new Rule 9A was added to the existing rules, requiring every unlisted public company to issue securities only in dematerialized form and facilitate the dematerialization of all its existing securities in accordance with the Depositories Act and the regulations thereunder. Following up on this, MCA announced the PAS amendment on 27 October 2023, impacting all companies, majorly private companies, by way of the company's Prospectus and Allotment of Securities Second Amendment Rules 2023, or the PAS Amendment Rules of 2023. Now, the PAS Amendment Rules encompass two major amendments. Firstly, with respect to the bearer share warrants issued under the Erstwhile Companies Act 1956, and secondly, mandatory dematerialization for all private companies, excluding small companies, which we will briefly discuss in this session. New Rule 9B has been inserted by way of the PAS Amendment Rules. It requires mandatory dematerialization of securities issued by private companies, requiring all private companies other than small companies and government companies to dematerialize their shares before the deadline of 1st October 2024. This amendment will ensure better transparency, efficiency, and mitigate fraud and the risk of loss and theft of share certificates. It also streamlines the share issuance process overall. Accordingly, twin obligations are placed on the company and the securities holder. As per the amendment, every private company which is not a small company must, within a period of 18 months of closure of such financial year, A. issue securities only in dematerialized form, and B. facilitate dematerialization of all its securities. Companies looking to raise capital need to note that before making any offer for issue of any securities or buyback of any securities or issue of any bonus shares or rights offer, they must ensure that the entire shareholding of its promoters, directors, and KMP has now been dematerialized. Additionally, any security holder who intends to transfer or subscribe to any securities of any company, specifically any private company, by way of either private placement, a bonus, or rights issue, need to also ensure that all such securities are held in dematerialized form before such transfer or subscription to such securities. Apart from this, compliance is applicable to an unlisted public company pertaining to holding shares in demat form are also applicable to all private companies. These mainly include applications with the depository for securing an ISIN for each type of security, informing the existing shareholders about the facility of dematerialization, and complying with all applicable regulations with respect to dematerialization. To ensure such compliance, the ROC now requires filing of return in Form PAS 6 on a half-yearly basis within 60 days from conclusion of such half of the financial year with respect to reconciliation of the share capital of the company. This is to bring to the notice of the depositories any difference between the issued share capital by the company and the capital held in demat form. Grievances of security holders are now to be filed with the IPF authority, which is entitled to initiate any action against a depository or depository participant RTA/STA as may be required after prior consultation with SEBI. Currently, there are no specific penal provisions prescribed for non-compliance of these provisions. Having said that, the general penal provisions prescribed under Section 450 of the Companies Act would be applicable. Per Section 450, the company and every officer of the company in default or any other person shall be liable to a penalty of INR 10,000 rupees, and in case of a continuing contravention, a further penalty of 1,000 rupees per day after the first instance of the contravention. The total penalty is capped at INR 2 lakh rupees in case of a company and INR 50,000 rupees in case of an officer who is in default or any other person.